something finally snapped in the system. For years, concealed carry in America was buried under red tape-long permit delays.
U.S. Supreme Court. In two 6-3 decisions, the court's conservative majority.
Now to a major ruling involving the Second Amendment. The Supreme Court struck down a New York law.
Vague, good cause rules and judges who quietly sided with bureaucrats instead of the Constitution. But that chapter just closed. In a landmark 6-3 ruling, the Supreme Court didn't just overturn one gun control law, they tore down the entire framework that allowed states to block your right to carry. This wasn't a small adjustment. It was a seismic shift, and it's already sending shockwaves. Courtrooms are scrambling, state laws are cracking, anti-gun politicians are sounding alarms they never thought they'd have to. So what actually happened, and what does it mean for you? You're in the right place. This is Second Amendment Advisor, where we leave out the politics and bring you the clear legal truth that directly affects your rights. Today, we'll walk through what this 6-3 decision really says, why it's more powerful than most people realize, how states are reacting or resisting, and what this means for you as a responsible gun owner. Let's begin. Chapter 1. The 6-3 ruling that shook the nation. The ruling hit like a hammer. 6 justices stood firm, 3 pushed back. But this decision wasn't historic just because of the numbers. It was about the message behind them. Why does this vote matter so much? A 6-3 outcome isn't narrow, it's not uncertain. It shows a rock-solid majority that's standing behind the Constitution, and it sends a loud, unmistakable message to every lower court. Follow the law, or get ready to be overruled. It also puts anti-gun states on notice. If you've been using your permit laws to delay, deny, or discourage carry rights, the clock just ran out. This case challenged a state law that forced everyday citizens to ask for permission just to carry a handgun outside their own homes. The court said enough is enough. They made it crystal clear. The right to bear arms doesn't stop at your doorstep. It doesn't depend on whether a local sheriff approves of you, and it doesn't require good cause, a waiting period, or a note from the government. This ruling resets everything. If the Second Amendment protects it, you don't need permission. Period. Chapter 2. The Permit Trap and Where It All Began. To understand why this ruling hit so hard, you've got to look back, way back. Because permit laws didn't start with safety in mind, they started with control. After the Civil War, southern states passed what were called black codes, laws designed to keep freed slaves from owning firearms. In 1911, New York introduced the Sullivan Act, which required permits to carry. But the real goal? Disarm immigrants and working-class citizens who were seen as untrustworthy. Over the next several decades, other states copied that model. They added sky-high fees, vague rules, and requirements that were nearly impossible to meet. Courts turned a blind eye, treating the Second Amendment like a second-tier right, not something worth defending. By the early 2000s, states were split. In may-issue states, permits were denied all the time, often for no reason at all. In shall-issue states, the rules were better, but still full of delays, red tape, and expensive hoops to jump through. This 6-3 Supreme Court ruling doesn't just fix one part of that broken system. It calls the entire thing into question. Because your rights aren't favors, they're not privileges, they're guarantees. Chapter 3. The Bruen Effect. A legal earthquake that set the stage. This ruling didn't appear out of thin air. It stands on the shoulders of one of the most important Second Amendment decisions in modern history, the Bruen ruling from 2022. That case flipped the legal world upside down. In Bruen, the Supreme Court said something judges had avoided for decades. No more balancing tests. No more, it feels reasonable. If a gun law isn't grounded in text, history, and tradition, it's unconstitutional. Period. That one decision changed everything. Before Bruen, states could say public safety, and judges would nod along, even if the law went far beyond anything the founders ever imagined. After Bruen, that door slammed shut. Now judges must ask a simple but powerful question. Would a law like this have made sense in 1791 or 1868? If the answer is no, the law falls. Not debated, not adjusted, it falls. This new 6-3 ruling is Bruen's younger, sharper, more aggressive brother. It doesn't just apply the historical test, it enforces it with full strength. It applies that test to permit systems, to delays, to good cause requirements, and it quietly signals that the same test may soon apply to bans, waiting periods, fees, and more. The court is sending a message to judges across the country. Stop inventing exceptions. Stop bending the Constitution. Start following it. For the first time in decades, the Second Amendment isn't being stretched, trimmed, or balanced. It's being respected, exactly as written. Chapter 4. ripple effects across the nation. The shockwave begins. The ruling wasn't even a day old before the country went into full reaction mode. Within hours, state governments were scrambling, lawyers were rushing to file challenges, and gun control advocates were openly panicking. Some states tried to adapt, others tried to fight. All of them realized the same truth: the rules just changed. California moved quickly, rewriting its carry laws, but expanded sensitive places so broadly that entire neighborhoods were nearly off limits. Critics say it's a ban disguised as a map. New York fired back with the Concealed Carry Improvement Act, a law many experts argue is even more restrictive than the system the court had just struck down. New Jersey doubled down, adding insurance mandates, more fees, and new restrictions that immediately drew lawsuits. Meanwhile, in the South, the momentum went the other direction. Texas, Florida, and Georgia openly cited the ruling as confirmation of their move toward full constitutional carry. And that's when the real frenzy began. Gun rights groups, GOA, FPPC, SAF, and others, filed lawsuits across multiple circuits. They treated the ruling like new ammunition, challenging laws that had been sitting untouched for decades. Restrictions that once felt untouchable were suddenly vulnerable. What happened next was exactly what the Supreme Court expected: a legal earthquake, with aftershocks spreading through every courtroom in the country. Judges who once had wide discretion now have a strict test to follow. States that tried to hold the line are already watching their laws crumble. And for the first time in years, the legal momentum is swinging hard in one direction: toward the Constitution, not away from it, and this is only the beginning. Chapter 5. States are pushing back, but losing fast. If you thought anti-gun states would roll over after the ruling, think again. They're not backing down, they're scrambling to hold on to power, but their tactics are starting to crack under pressure. Here's what they're doing: expanding sensitive places to absurd levels, including parks, churches, entire cities, even parking lots. Demanding liability insurance before you're allowed to carry. Imposing long training hours, outrageous fees, and a mountain of paperwork. Passing so-called emergency laws to freeze new applications and stall permits in limbo. But there's one big problem for all of them. None of this has any historical backing. There were no sensitive zones in colonial America. The founders didn't buy insurance to exercise their rights, and they sure didn't ask the British for permission to carry a firearm. That's exactly why these new laws are already being dragged into court. And this time, judges can't hide behind the old excuses, because the message from the Supreme Court couldn't be clearer. You can't ban a right just because you're afraid of it. Chapter 6. The new legal standard that changes everything. This ruling didn't just knock down one permit law, it rewrote the rules for every future Second Amendment case across the entire country. The court created a new strict legal test. No more loopholes. No more vague balancing acts. From now on, there's a clear framework every judge must follow. Text. What does the Second Amendment actually say? That's where it starts. History. Would a law like this have existed in 1791 or 1868? That's the timeline that matters. Tradition. If there's no historic match, the modern law can't stand. Period. That's it. No more public safety claims used as shortcuts. No more judicial activism dressed up as concern. The Constitution comes first, and it doesn't bend to political fear. The court reset the precedent. Judges can no longer make it up as they go. They now have marching orders: protect the right, don't invent exceptions. And what does that mean for gun owners? It means dozens of outdated laws, from permit delays to arbitrary bans, are now on borrowed time. The courts are shifting, the balance has changed, and the Second Amendment is no longer up for interpretation. It's being restored. Chapter 7. How this ruling changes your daily life. Big rulings can seem distant, like something that only affects lawyers and courtrooms, but not this one. The Supreme Court's 6-3 decision is already changing how you carry, how you travel, and how confident you feel in your own rights. Here's what's shifting right now. Permits, good cause, and may issue laws are collapsing. States can no longer force you to justify why you want to carry. Traveling. More states may soon have to honor your carry permit, even if you're just passing through. Traffic stops. If you're carrying legally, it's now presumed lawful, not suspicious. That changes how officers approach you and how courts see your case. Shall issue states, even the more gun-friendly states, are feeling the pressure to go further toward full constitutional carry. Self-defense. You no longer have to hope the law is on your side. It is. This ruling reinforces that your right to defend yourself doesn't depend on someone else's approval. Millions of Americans who once walked on legal eggshells now stand on solid ground. You're not asking for a privilege. You're exercising a right freely and lawfully. And the message from the court couldn't be clearer. The right to bear arms is no longer up for negotiation. Chapter 8. The political firestorm has already begun. No ruling this strong comes without backlash, and this one, it lit a fire. The moment the decision dropped, political shockwaves hit Washington, state capitals, and media outlets coast to coast. Now the battle lines are forming fast. Here's what's happening right now. Senators Schumer, Murphy, and Feinstein are already pushing new gun restrictions, trying to pass laws that work around the ruling. Blue states are redrawing the map, expanding sensitive zones to make entire cities off limits to lawful carry. Insurance mandates and extra taxes on gun owners are being floated as new barriers. Red states, on the other hand, are doing the opposite, doubling down on constitutional carry and leaning into the ruling as a legal cover. And with the 2026 midterms around the corner, it's clear this isn't just a legal fight anymore. It's political, ideological, and cultural. Gun owners may have won in the courtroom, but the battle is far from over, because when freedom wins around, the system doesn't admit defeat. It just regroups. And that means every gun owner needs to stay informed, stay engaged, and stay ready, because the next round is already being planned. Chapter 9. The Domino Effect. What's already falling. This ruling was about permits, but make no mistake, it kicked the door wide open. What started with one case is now triggering a chain reaction across the country. Every major gun control law is suddenly on shaky ground, and the lawsuits? They're coming fast, hard, and everywhere at once. Here's what's already under fire. Assault weapons bans being struck down in multiple circuits. Courts are finally asking whether these bans have any historical basis. Magazine restrictions challenged using the same Bruen-style arguments, and many are already collapsing. Waiting periods, judges are questioning whether any of these delays ever had real constitutional footing. Sensitive place laws, cities trying to ban carry everywhere, are finding out that everywhere doesn't mean legal. Training mandates and government fees, now being challenged as financial barriers to a constitutional right. This ruling didn't close a chapter. It opened a floodgate. For the first time in decades, gun owners aren't just defending what's left, they're taking ground back. This 6-3 decision is the legal battering ram that's now slamming into every unconstitutional law still standing. And the message is clear. The fight isn't over, but the tide has turned. Chapter 10. A turning point for the Second Amendment. Every generation hits a moment where the Constitution gets tested. For the Second Amendment, this 6-3 ruling might be that moment, the one that shifts the course of history. Here's why this ruling is so important. Not just legally, but philosophically. It doesn't ask the courts to balance your rights. It demands they restore them. It puts the right to bear arms on the same level as free speech, religion, voting, and every other foundational liberty. It exposes how fear-based laws, not freedom-based ones, have dominated gun policy for over 100 years. It sends a clear signal to judges. Your job is to protect liberty, not manage it. And it tells every politician in America the Constitution is not a suggestion, it's the law. This isn't just a courtroom win, it's a national reset. It's proof that rights don't need permission slips, they just need defending. It's a return to the original vision, to the words the founders actually wrote, and the meaning they actually intended. And here's the truth, this is just the beginning. Your rights, your voice, your future. What you do next, how you stay informed, how you stand your ground, that's what decides where this fight goes from here. Where we stand now. The Supreme Court has officially reset the rules for gun ownership in America. States are scrambling, some are panicking, others are pushing back or rushing to rewrite their laws overnight. But gun owners, for the first time in a long time, you're standing on solid constitutional ground. Still, don't let your guard down. This wasn't the final word. It was the opening shot. The court made the law clear, but the political machine is already working on its next move. That's why now, more than ever, you need to stay sharp, stay informed, and stay engaged in this fight. This is Second Amendment Advisor, no politics, no spin. Just the straight legal truth that affects your future. If this helped you understand what's really going on, hit like, subscribe, and turn on notifications so you never fall behind the next wave of changes. And share this with another gun owner who deserves to hear the truth before lawmakers try to bury it. Because the more we educate, the harder it becomes for any court, Congress, or governor to steal your rights quietly. Stay alert, stay armed, stay free.